Hello everyone, welcome back to my lecture series on Hindu law, and we are discussing Unit 2 Marriage and Kinship. This is the third video under Marriage and Kinship series, and in this video we will discuss about restitution of conjugal rights, which is part of Section 9 of Hindu Marriage Act 1955. Okay, the entire series of Hindu law is based on the textbook title Hindu Law written by Dr. Rakesh Ainapur, which is available on Amazon, Flipkart, and Vision Bookstore for purchases, and then you can also download from Google Play Store and Amazon Kindle. In the Hindu law lecture series, so far we discussed about the meaning of marriage and kinship, evolution of institution of marriage and family in Indian context, laws which were there prior to Hindu Marriage Act, and also we discussed overview of Hindu Marriage Act, and we covered section 5 to 8 in a previous video. And from this video onwards, we will discuss matrimonial remedies. In the next 3 to 4 videos, we will talk about various matrimonial remedies. So just a recap on Hindu Marriage Act. Hindu Marriage Act was introduced in 1955. The key sections are where section 5 to 8 deals with solemnization of marriage and then registration of marriage. Section 9 and 10 deals with restitution of conjugal rights and judicial separation. Section 11 to 18 discusses nullity of marriage and divorce, and 19 to 20 talks about jurisdiction and procedures, and 29 to 30 talks about savings and repeal. So we covered already this point 5 to 8, and let's discuss about these points now. Under Hindu law, there are some matrimonial remedies are available in case of dispute arises between husband and wife or between spouses. So the aggrieved party should be provided with a relief. So that's why there are some remedies are provided in Hindu law. The first one is restitution of conjugal rights. So whatever marital rights are there, restoring of that, which is about in section 9. Then judicial separation, allowing husband and wife to live separately. And then section 11 and 12 talks about void and voidable marriages, which are void and which are voidable. In case of void, the other spouse will be protected. The aggrieved party will be protected. And then we have a divorce is a last resort, which is a section 13 deals with that. And section 13B deals with divorce by mutual consent. So in this video, our focus is on restitution of conjugal rights. Okay. So restitution of conjugal rights, which is part of section 9. We know that the very essence of marriage is the lifelong companionship, where husband and wife will live together as a legally wedded couples, right? But in some instances where one spouse unjustifiably withdraw from the marital union, take an example here, husband and wife. If husband withdraws the companionship of wife and stays separately, in this case, aggrieved party is wife, right? So wife can approach to a district court through petition for restitution of conjugal rights. Restitution of conjugal rights means requesting for restoration of marital rights. Okay, it is a restoration of marital rights or requesting for a cohabitation, because cohabitation is an essential element of any marriages. So here aggrieved party, the wife can request or through a petition can approach to a district court for requesting a restoration of a marital rights. So here is a section 9 which is running as follows. You can go through this. You can go through this, and court will be granting restitution of a conjugal right decree, provided if husband withdraw the companionship of wife without any proper reasons. Okay. If a husband has withdrawn and stayed separately without any proper reasons, then court will give a decree for restitution of conjugal rights, where husband has to go back and live with the wife. This is about restitution of conjugal rights. But few people argued that this is a right of an individual who can live as per his whims and fancies. Article 14 and Article 21 has granted a rights, right, as a fundamental rights for individual, where person can live independently with the right to privacy and there is a human dignity. But there is a contradicting opinion in court orders. In one of the case where T. Sarita versus V. Venkata Subbaya, Andhra Pradesh High Court determined that remedy of seeking restitution of conjugal right is in contravention to the right to privacy and human dignity, which is given in Article 14 and 21. But however, there is a contrasting viewpoints were seen in the case of Harvinder Kaur versus Harvinder Singh, a Delhi High Court, uh, where and in the case of Saroja Rani versus Sudarshan Kumar, a Supreme Court case, where the courts concluded that Section 9 does not infringe upon the provisions of Article 14 and 21. So summarily, because it is a Supreme Court case, we can say or we can conclude that the Section 9, if any remedy is given under Section 9, it is not contravention to Article 14 and 21. So the relief under Section 9 will be given subject to if the marriage is a valid marriage. We already gone through what are the valid marriages. We will see what are the void marriages and voidable marriages under Section 11 and 12 in the next coming videos. And the person should have withdrawn without any reasonable excuse. And the aggrieved party must apply for restitution of conjugal rights in a district court. If the court is satisfied with the statements, then they will give a decree. So two important elements, there should be withdrawal from the society. The companionship should not be there. It should be a physical separation. And the second one is a reasonable cause. Okay, here are some example. Okay, we say that there should be a separation. What is called as separation? There is a one in one of the case Alka Bhaskar versus Sachidanand Parke. Alka was employed at a location distant from her husband's residence. Okay, so husband went to a court and approached for restitution of conjugal rights. In this case, as Alka was working and the husband's house was very far, so court clearly said that house means it is not only husband's or husband's parent house. House can be anything, okay? They can have a new house near to Alka's office. So that's why it is not necessary that the both should live in husband's house or husband's parents' house. Again, in the case of Powell versus Powell, it is held that if within the same house, if husband and wife are living separately without any physical relationship, and then it is considered as withdrawal from the society. So I hope you are clear about the term withdrawal from the society means living separately, but living separately without for the reason of a work, it will not be called as living separately. So the second point is reasonable cause. There should be some reasonable cause to stay separately. Withdrawing from the society, there should be some reasonable cause. In the case of Harminder Kaur versus Harvinder Kaur, court has given few reasons for separation. One is grossly indecent behavior, extravagance of living of spouse, excessive alcoholic, refusal of marital intercourse without any sufficient reason, development of insanity, agreement to live separately, and cruelty. These are all the valid grounds for separation. If person is living separately without any one of these reasons, then court will consider as it is a not valid separation. So they may give a decree for restitution of conjugal rights. So here are a few more cases in Sumana Bai versus Anandrao, where husband questioned the chastity of a wife. So in that case, wife felt insulting and then started living separately. In the case of R. Natarajan versus Sujata Vasudevan, if wife is asking to live separately from husband because of a aged parents of the husband is not a reasonable excuse. It is a responsibility of husband and wife to take care of their old parents. So here, this is a detailed note on reasonable causes. The two important thing: withdrawal from the society with a valid, reasonable reasons. So then only court agrees for separation. Otherwise, court will give a decree for restitution of conjugal rights in favor of aggrieved party. So what are the burden of proof in this? There are two levels for it. At the first, aggrieved party has to prove that the other party, the respondent, has withdrawn from his or her society. Husband and wife example what we took. If husband withdrawn from the society, then wife has to prove that he is living separately. There is no valid reason for it. Okay, there is no insult, there is no cruelty, nothing. But even then, husband is living separately. So wife has to prove that. It is a burden of proof lies on the wife. And the second level, the husband has to prove that there is some valid reasons. That's why he is staying away. Once the court is satisfied, then decision will be provided. So let's recap. Here is a summary of what we discussed under Section 9. So there should be an unjust withdrawal from the society. There will not be any reasonable cause. So if there is no reasonable excuse, then aggrieved party will initiate the proceedings. The burden of proof, initially it is lying on the party who will aggrieved party, and after that the respondent has to prove. So always courts focus in case of restitution of conjugal rights is to encourage reconciliation between husband and wife. But because of the modern trend and other things, the law can be misused here. That is the biggest challenge for restitution of conjugal rights. So here is a summary of Section 9, Restitution of Conjugal Rights. One important case study on restitution of conjugal rights is Sushil Kumari Dang versus Prem Kumar. In this case, it is court clearly made it that, okay, even the aggrieved party proved that there is a reasonable excuse. It is at the court's discretion to grant restitution of conjugal rights. The other two cases are on judicial separation, which is part of Section 10. We will discuss about this in next video. Thank you so much, guys. Thank you so much for your patience and listening my videos. I request you to please subscribe to my channel and also share it with your friends. Thank you.